Okay, I'm reading Escobedo versus Illinois of 1964, just court. On the night of January 19th, petitioner's brother-in-law was fatally shot. A few hours later, petitioner was taken into custody for questioning, but he made no statement and was released the following afternoon pursuant to a writ of habeas corpus obtained by his retained counsel. On January 30th, one D. Gerlando, who was then in police custody and who was later indicted for the murder along with petitioner, stated that petitioner had fired the shots which killed his brother-in-law. That evening, petitioner was again arrested and taken to police headquarters. Because he had consulted with his attorney, I would like to have advice from my lawyer. Shortly after petitioner reached police headquarters, his retained lawyer arrived and spent the next 3 or 4 hours trying unsuccessfully to so was repeatedly told that he could not see his client and that he would have to get rid of habeas corpus to his lawyer. At one point, petitioner and his attorney came into each other's view for between petitioner and D. Gerlando. Petitioner denied that he had fired the fatal shots. He maintained that D. Gerlando was lying and in the presence of police told him, "I didn't shoot Manuel, you did it." In this way, petitioner admitting to some knowledge of the crime after that, getting himself in the murder plot. At this point, an assistant prosecutor arrived to take a statement. The statement, made in response to carefully framed questions, was admitted into evidence. Petitioner was convicted of murder, the Supreme Court of Illinois affirmed. The critical question in this case is whether, under the circumstances, the refusal by the police to honor petitioner's request to consult with his lawyer during the course of an interrogation constitutes a denial of the assistance of counsel in violation of the Sixth Amendment to the Constitution as made obligatory upon the states by the 14th Amendment. Gideon, and thereby renders inadmissible in a state criminal trial any incriminating statement elicited by the police during an interrogation. In Messiah, the court observed that a constitution which guarantees a defendant the aid of counsel at trial could surely vouchsafe no less to an indicted defendant under interrogation by police in a completely extrajudicial proceeding. Anything less might deny a defendant effective representation by counsel at the only stage when legal aid and advice would help him. So, I found the issue. We're getting into case law right now. And above that were the facts. The interrogation here was conducted before petitioner was formally indicted, but in the context of this case, that fact would make no difference. When petitioner requested and was denied an opportunity to consult with his lawyer, the investigation had ceased to be a general investigation of an unsolved crime. Petitioner had become the accused, and the purpose of the interrogation was to get him to confess his guilt, despite his constitutional right not to do so. At the time of his arrest and throughout the course of the interrogation, the police told petitioner they had convincing evidence that he had fired the fatal shots without informing him of his absolute right to remain silent in the face of this accusation. The police urged him to make a statement. Petitioner, a layman, was undoubtedly aware that under Illinois law, the mere admission of complicity in a murder plot was legally as damaging as an admission of firing of the fatal shots. The guiding hand of counsel was essential to advise petitioner of his rights in this delicate situation. This was the stage when legal aid and advice were most critical to petitioner. Messiah, it would exalt form over substance to make the right of counsel under these circumstances depend on whether at the time of interrogation the authorities had secured a formal indictment. Petitioner had, for all practical purposes, already been charged with murder. That's a little bit concerning that we're just gonna say that he's at the stage of deserving a right to counsel without really exploring that more. So we're just not touching that issue. In Gideon, I'm sure the dissent it make the trial no more than an appeal from the interrogation. And the right to use counsel at the formal trial would be a very hollow thing if, for all practical purposes, the conviction was already assured by pretrial examination. In Groban, one can imagine a cynical prosecutor saying, "Let them have the most illustrious counsel now. They can't escape the noose. There is nothing the counsel can do for them at the trial." It is argued that if the right to counsel is afforded prior to indictment, the number of confessions obtained by the police will diminish significantly, because most confessions are obtained during the period between arrest and indictment. And any lawyer worth his salt will tell the suspect in no uncertain terms to make no statement to police under any circumstances. This argument, of course, cuts two ways. The fact that many confessions are obtained during the period points up its critical nature as a stage when legal aid and advice are surely needed. The right to counsel would indeed be hollow if it began at a period when few confessions were obtained. There is necessarily a direct relationship between the importance of the stage to the police in their quest for confession and the criticalness of that stage to the accused for legal advice. Our Constitution, unlike some others, strikes the balance in favor of the right of the accused to be advised of his lawyer of his privilege against self-incrimination. We have learned the lesson of history, ancient and modern, that a system of criminal law enforcement which comes to depend on this confession will, in the long run, be less reliable and more subject to abuses than a system which depends upon extrinsic evidence independently secured through skillful investigation. We have also learned the lesson of history, ancient and modern, that a system of criminal law enforcement which comes to depend upon a confession, will in the long run be less reliable and more subject to abuses than a system which depends on extrinsic evidence independently secured through skillful investigation. We have also learned that the companion lesson of history, that no system of criminal justice can or should survive if it comes to depend for its continued effectiveness on the citizens' abdication through unawareness of their constitutional rights. No system worth preserving should have to fear that if an accused is permitted to consult with a lawyer, he will become aware of and exercise these rights. If the exercise of constitutional rights will thwart the effectiveness of a system of law enforcement, then there is something very wrong with that system. We hold, therefore. So in other words, it seems like they're trying to make a fundamental case that people should be wise of their rights. We hold, therefore, that whereas here the investigation is no longer a general inquiry into the unsolved crime, but has begun to focus on a particular suspect, the suspect has been taken into police custody. The police carry out a process of interrogations that lends itself to eliciting incriminating statements. The suspect has requested and been denied an opportunity to consult with a lawyer, and the police have not effectively warned him of his absolute constitutional right to remain silent. The accused has been denied. This has made obligatory upon the states by the 14th Amendment, and that cites Gideon, and that no statement elicited by the police during the interrogation may be used against him at a criminal trial. It's funny, they then get into when the right to counsel applies, which is not a question they were trying to answer. Investigation is no longer general inquiry into an unsolved crime, but has begun to focus on a particular suspect who's taken into police custody and interrogated. This is when the right vests. Crime by gathering information from witnesses and by other proper investigative efforts. We hold only that when the process shifts from investigatory to accusatory, when the focus is on the accused and the purpose is to question, our adversary system begins to operate, and under the circumstances here, the accused must be permitted to consult with his lawyer. The judgment of the Illinois Supreme Court is reversed in the case remanded for proceedings not inconsistent with this conceived, and that it's criminal law enforcement. And this is a rule. This isn't just a holding. Stewart dissenting Messiah is not in point here, putting to one side the fact that the case now before us is not a federal case. The vital fact remains that this case does not involve the deliberate interrogation of a defendant after the initiation of judicial proceeding against him. The court disregards this basic difference between the present case and Messiah's, and with bland assertion that that fact should make no difference. It is that fact, I submit, which makes all the difference. Under our system of criminal justice, the institution for formal, meaningful judicial proceedings by way of indictment, information, and arraignment marks the point at which the criminal investigation has ended and adversary proceedings have commenced. That's what I was saying. It is at this point that the constitutional guarantees attach which pertain to a criminal trial. Among those guarantees are the right to speedy trial, the right of confrontation, and the right of to trial by jury. Another is a guarantee of the assistance of counsel. The confession, which the court today holds inadmissible, was a legitimate police investigation of an unsolved murder. The court says what happened during the investigation affected the trial. I had always supposed that the whole purpose of the police investigation of a murder was to affect the trial of a murderer, and that it would be only an incompetent, unsuccessful, and corrupt investigation which would not do so. The court further says that the Illinois police officers did not advise the petitioner of his constitutional rights before he confessed the murder. Yeah, it's a little much to say this is a perfectly legitimate police obligation, because they're letting witnesses confront one another, and that would make what they say by nature unreliable. And they didn't give them their rights, like just said here. But he confessed before he confessed the murder. This court has never held that the Constitution requires the police to give any advice under circumstances such as these. Supported by no stronger authority than its own rhetoric, the court today converts a routine police investigation of an unsolved murder into a distorted analog of a judicial trial. We're confronting witnesses. I mean, that's why it imports into the investigation constitutional concepts historically applicable only after the onset of formal prosecutorial proceedings. In doing so, I think the court perverts those precious constitutional guarantees and frustrates the vital interests of society in preserving the legitimate and proper function of purposeful police investigation. White, Clark, and dissenting opinions, right? Clark, Stewart, White, Harlan. There's only 4. In Messiah, the court held that to secure admissions from the accused. And the court now moves that date back to the time when the prosecution begins to focus on the accused. Although the opinion purports to limit the facts of the case, it would be naive to think that a new constitutional right announced will depend upon whether the accused has retained his own counsel or has asked to consult with counsel in the course of interrogation. At the very least, the court holds that once the accused becomes a suspect, presumably in arrest, any admission made to the police, therefore, is inadmissible in evidence unless the accused has waived his right to counsel. The decision is thus another major step in the direction of the goal which the court seemingly has in mind. To bar from evidence all admissions obtained from the individual suspect of crime, whether involuntarily made or not. It does, of course, put us on one step ahead of the court. Seems driven by the notion that it is uncivilized law enforcement to use an accused's own admissions against him at trial. It attempts to find a home for this new and nebulous rule of due process by attaching it to the right to counsel, guaranteed by the process guarantee of the 14th Amendment. The right to counsel now not only entitles the accused to counsel's advice and aid in preparing for trial, but stands as an impenetrable barrier to any interrogation once the accused has become a suspect. From that moment, apparently, his right to counsel attaches a rule wholly unworkable and impossible to administer unless the police cars are equipped with public defenders and undercover agents and police informants have defense counsel at their side. I would not abandon the court's prior cases to finding with some care and analysis the circumstances requiring the presence or aid of criminate himself. But it would be very doubtful that the resulting admissions could be used against him when the